House Committee on Human Services will now come to order. The clerk will call the roll.
Chair Frank,
Here.
Vice Chair Rose,
Here.
Representative Click,
Here.
Representative Shaheen,
Here.
Representative Ramos,
Here.
Representative Noble,
Here.
Representative Campos,
Here.
Representative Hull,
Here.
and Representative Manuel.
A quorum is present. Members, today we're going to take up pending business and hear new bills and take public testimony. A reminder to those in the audience wishing to testify on the bills, you must fill out a witness affirmation form. Please do this at the witness registration kiosk outside the hearing room, or if you need assistance registering, you can approach our Assistant Clerk Blake to help with registration. You can also speak to him if you need a translator or if you have a disability that you need, for which you need assistance. If you've already registered and you wish to change your position, please let us know when you're called to speak, or please see the Assistant Clerk. Please don't register twice. Don't be that person. Testimony will be limited to 3 minutes. There is a timer. When the light turns yellow, you got 30 seconds remaining. When the light turns red, please wrap up. If members ask questions, you'll get more time. If you have any handouts that you wish to distribute, please give them to the Assistant Clerk, and he'll distribute to the members. Members, any questions or comments? All right, we're going to vote out some bills. First order of business, we're going to be voting out some bills. So the chair lays out House Bill 336 by Toth as pending business. Members, we heard this bill in committee last week. House Bill 336 relates to notice regarding certain benefits which a representative payee or fiduciary has been appointed for a child in the conservatorship of the Department of Family and Protective Services. This bill seeks to require increased reporting related to a child's benefits, assets, and applications for benefits. Excuse me. Lips are having trouble moving this morning. Representative Noble moves that House Bill 336 without amendment be reported favorably to the full House with a recommendation that it do pass and be printed. Clerk will call the roll.
Chair Frank,
Aye.
Vice Chair Rose,
Aye.
Representative Click,
Aye.
Representative Shaheen,
Aye.
Representative Ramos,
Aye.
Representative Noble,
Aye.
Representative Campos,
Aye.
Representative Hull,
Aye.
Representative Manuel.
There being 9 ayes and 0 nays, the motion prevails. The chair lays out House Bill. The chair lays out House Bill 463 as pending business by Representative Hull. Members, we heard this bill in committee 2 weeks ago. House Bill 463 relates to medical examinations for certain children entering the conservatorship of the Department of Family and Protective Services. The bill requires that DFPS follow Section 264.1076 of the Texas Family Code as it was passed in 2017 pertaining to the 3-day medical examination. Members, are there any questions, or Representative Hull, any comments? Yeah, and I think this is one, by the way, if you recall, that the head of DFPS said that they had not implemented it the way the bill was passed in 2017, which I appreciate. I think this is something that we have talked about a number of times. I think the agencies should implement things according to the bills that are passed. So, members, any questions? All right. Representative Noble moves that House Bill 463 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. Clerk will call the roll.
Chair Frank,
Aye.
Vice Chair Rose,
Aye.
Representative Click,
Aye.
Representative Shaheen,
Aye.
Representative Ramos,
No.
Representative Noble,
Aye.
Representative Campos,
Aye.
Representative Hull,
Aye.
Representative Manuel.
There being 7 ayes and 1 nay,
Oh, yeah, you're good.
the motion prevails. There being 7 ayes and 1 nays, the motion prevails. Let me try that again. Okay, the chair lays out House Bill 475 as pending business by Representative Hull. Members, we heard this bill as well in committee 2 weeks ago. House Bill 475 relates to certain policies and procedures for health specialty consultations in certain child abuse and neglect investigations and assessments. This bill requires the Forensic Assessment Center Network that any medical professionals who are consulted in any hospital involved in a consult to produce all medical records used in and created by the investigation and or consult by the FACN to the parent, guardian, and attorney who is representing them. Members, any questions? Again, any comments? All right. Yeah. This is it for you today. Representative Shaheen moves that House Bill 475 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. Clerk will call the roll.
Chair Frank?
Aye.
Vice Chair Rose?
Could you come back to me?
Yeah.
I'm sorry?
Representative Glick?
I can't remember what this was.
Representative Shaheen?
Aye.
Representative Ramos?
Nay.
Representative Noble?
Aye.
Representative Campos?
Yes.
Representative Hull?
This is the one and I didn't know for last.
Representative Manuel? Vice Chair Rose?
Nay.
7-2. There being 7 ayes and 2 nays, the motion prevails.
I think I was a no on the first one and a yes on this one. There was one on my
The chair lays out House Bill 637 as pending business by Representative Bales. Members, we heard this bill in committee last week. HB 637 relates to the payment of permanency care assistance after the child's 18th birthday. This establishes that the department may extend these benefits after the month in which the child turns 18 if the child is regularly attending high school or enrolled in a program leading towards a high school diploma or high school equivalency certificate. Representative Shaheen offers a committee substitute. The committee substitute clarifies that the bill's intent that permanency care payments only extend while the youth is pursuing a high school diploma or equivalent program. It clarifies the previous incorrect assumption regarding the payments continuing to the age of 21 in all circumstances. Is there objection to the adoption of the committee substitute? The chair hears none, and substitute amendment is adopted. Representative Shaheen moves that House Bill 637 as substituted be reported favorably to the full House with the recommendation that it do pass and be printed. Clerk will call the roll.
Chair Frank?
Aye.
Vice Chair Rose?
Aye.
Representative Glick?
Aye.
Representative Shaheen?
Aye.
Representative Ramos?
Aye.
Representative Noble?
Aye.
Representative Campos? Representative Hull? Representative Manuel?
There being 9 ayes and 0 nays, the motion prevails. Can she lay out her own committee substitute?
If she wants to, but I would read this just for today.
Sorry, what's that?
Her staff had asked, and I said that I was putting this in there, so maybe just ask her if she wants to.
Do you want me to put this out there?
Yes.
It's got a committee substitute. That's good, too. The chair lays out House Bill 728 as pending business by Vice Chair Rose. Members, we heard this bill in committee last week. House Bill 728 relates to the statewide Interagency Aging Services Coordinating Council. It establishes a statewide Interagency Aging Services Coordinating Council to ensure a strategic statewide approach to the interagency aging services. Representative Click offers a committee substitute. The substitute specifies that the reports created by the council are recurring when the reports are to be submitted by that the council is subject to sunset review and the terms of service. It also requires the head of each agency subject to the report to submit an implementation plan and provide justification for any recommendation that will not be implemented. Is there objection to the adoption of the committee substitute? The chair hears none, and substitute amendment is adopted. Representative Campos moves that House Bill 728 as substituted be reported favorably to the full House with the recommendation that do pass and be printed. Clerk will call the roll.
Chair Frank?
Aye.
Vice Chair Rose?
Aye.
Representative Click?
Aye.
Representative Shaheen?
No.
Representative Ramos?
Aye.
Representative Noble?
Aye.
Representative Campos? Representative Hull? Representative Manuel?
There being 8 ayes and 1 nay, the motion prevails. All right, Chair lays out House Bill 729 as pending business by Vice Chair Rose. Members, we heard this bill as well in committee last week. HB 729 relates to the statewide Intellectual and Developmental Disability Coordinating Council. It establishes a council to ensure a strategic statewide approach to intellectual and developmental disability services. Representative Click offers a committee substitute. This substitute specifies that the reports created by the council are recurring. Again, the same as the last bill, but when the reports are to be submitted by, that the council is subject to sunset review and the terms of service. It also requires the head of each agency, subject to the report, to submit an implementation plan and provide justification for any recommendation that will not be implemented. Is there objection to the committee substitute, or to the adoption, excuse me, of the committee substitute? Chair hears none, and the substitute is adopted. Representative Ramos moves that House Bill 729 as substituted be reported favorably to the full House with a recommendation that do pass and be printed. Clerk will call the roll.
Chair Frank?
Aye.
Vice Chair Rose?
Aye.
Representative Click?
Aye.
Representative Shaheen?
No.
Representative Ramos?
Aye.
Representative Noble?
Aye.
Representative Campos?
Aye.
Representative Hull? Representative Manuel?
There being 8 ayes and 1 nay, the motion prevails. All right, the chair lays out House Bill 793 as pending business by Representative Noble. Members, we heard this bill in committee last week. House Bill 793 relates to the selection and reimbursement of certain persons providing services required under the service plan filed by DFPS. This bill allows parents to choose a provider for CPS-ordered services. Representative Noble, Representative Hull offers a committee substitute. The committee substitute removes the requirement that services obtained from the provider selected by the family be provided using an evidence-based program or practice or a promising program or practice. It also removes the requirement that the department convene a work group to assist in developing rules. Is there objection to the adoption of the committee substitute? Chair hears none, and the substitute is adopted. Representative Hull moves that House Bill 793 as substituted be reported favorably to the full House with a recommendation that do pass and be printed. Clerk will call the roll.
Chair Frank?
Aye.
Vice Chair Rose?
Aye.
Representative Click?
Aye.
Representative Shaheen?
Aye.
Representative Ramos?
Nay.
Representative Noble?
Aye.
Representative Campos?
Aye.
Representative Hull?
Aye.
Representative Manuel?
There being 8 ayes and 1 nay, the motion prevails. Chair lays out House Bill 833 as pending business. Members, we heard this bill in committee last week. House Bill 833 relates to an evaluation by the Housing and Health Service. This is by Representative Campos. House Bill 833 relates to an evaluation by the Housing and Health Services Coordination Council of the 211 services provided by the Texas Information Referral Network. This bill tasks HHSC with an evaluation of the 211 Texas Informational Referral Network for customer satisfaction, delivery of customer resources and referrals, system limitations, and determination of necessary funding to keep up with the increased calls. Members, any questions? All right, Vice Chair Rose moves that House Bill 833 without amendment be reported favorably to the full House with a recommendation that it do pass and be printed. Clerk, please call the roll.
Chair Frank?
Aye.
Vice Chair Rose?
Aye.
Representative Click?
Aye.
Representative Shaheen?
Aye.
Representative Ramos? Representative Noble?
Aye.
Representative Campos?
Aye.
Representative Hull?
Aye.
Representative Manuel?
Aye.
Why don't you go ahead and call her name again.
Representative Ramos?
Aye.
Okay.
All right. There being 9 ayes and 0 nays, the motion prevails. And I hope, and by the way, I know this is the first, or I guess second time we've been voting out. We're trying to let y'all know before, what time, 3, what bills are going to be voted, so you know before the day before. I will try never to surprise you with the vote, although it still gets confusing when we're voting out a number of them, so apologize. All right, the chair lays out House Bill 1010 as pending business by Representative Turner. Members, we heard this bill in committee last week. House Bill 1010 relates to the insurable interest of certain persons providing care to individuals with disability in the life of those individuals. It states that a person caring for an individual with an intellectual or developmental disability at a state-supported living facility, assisted facility, intermediate care facility, or group home setting does not have an insurable interest in the life of the individual under their care unless the two are related. Representative Manuel offers up a committee substitute. The committee substitute defines relatives and ensures all types of life insurance are covered by the bill. Is there objection to the adoption of the committee substitute? The chair hears none, and the substitute is adopted. Representative Hull moves that House Bill 1010 as substituted be reported favorably to the full House with the recommendation that it do pass and be printed. Clerk, please call the roll.
Chair Frank?
Aye.
Vice Chair Rose?
Aye.
Representative Click?
Aye.
Representative Shaheen?
Aye.
Representative Ramos?
Aye.
Representative Noble?
Aye.
Representative Campos?
Aye.
Representative Hull? Representative Manuel?
There being 9 ayes and 0 nays, the motion prevails. All right. All right. Excuse me. And Chair lays out House Bill 2359 and recognizes Representative Wally to explain his bill.
Good morning, Chairman Frank and members, Vice Chair Rose. Appreciate the opportunity to lay out this very important bill. I know most of you guys have spent some time on this bill, so appreciate the opportunity to lay out HB 2359. HB 20, can y'all hear? Okay, sorry. HB 2359 proposes to set caseload limit goals for certain caseworkers in child and adult protective services and in child care licensing services. In February 2020, DFPS announced CPS conservatorship workers, also known as CVS, would begin to maintain caseloads between 14 and 17 per worker, with one child defined as one case. This is a significant and long overdue step toward improving the quality of services that foster children receive while in the state's care. Establishing a caseload standard for every other part of DFPS would similarly help protect vulnerable children and adults in every community across Texas. Recommendations to reduce caseloads have come from the Sunset Advisory Committee, the Texas Adoptive Review Committee, the KC Family Program, the Stephen Group, the Texas Comptroller, the Texas Appleseed, and DFPS appropriations request in their LARs. Dangerously high caseloads have been at the foundation of the ongoing federal lawsuit that found that the state violated the constitutional rights of foster children to not be harmed by the state. So some of the key points about HB 2359 specifies that every caseload numbers for each category of caseworker and non-exceedance rates for call waiting times and call abandonment rates, which includes specifically CPS investigators, not more than 15 cases, CPS providers of family-based services, safety services, not more than 10 cases, CPS CVS workers, not more than 20 cases, foster and adoption programs, not more, or folks that work in foster and adoption programs, not more than 20 cases, child care licensing daycare investigators, not more than 17 investigations, adult protective services specialists providing adult protective services through in-home programs, not more than 22 cases at a time. And then lastly, the bill extends the appropriate funds to DFPS to ensure that the abuse, neglect, and exploitation hotline meets its call processing goals of 5 minutes or less hold time and a 25% call abandonment rate each fiscal year. In closing, without HB 2359 taking significant steps to lower caseloads and increase retention rates, the same systemic problems will continue to hinder DFPS's ability to function and retain staff. I thank you for the opportunity to present this bill. This is not the first time, Chairman Frank, you've heard me in front of this committee regarding this particular bill. It's something that we've been working on since, and I want to thank all of you on this committee, because I did serve on this committee in 2009 in my first session. I got to serve on Article 2 of the budget that dealt with DFPS's, or Health and Human Services. Article 2 was very moved by the staff. I visited with staff in my home county, talked to DFPS caseworkers individually, but also do a lot of work, not a lot, but I do enough work in my other capacity, representing children in permanent managing conservatorship, did an internship in law school with the Children's Clinic, And so I've had a extensive experience with caseworkers and dealing with them. They work hard. They're overworked. They obviously do not do that work for the money. But we should also recognize that this state has a responsibility to fully fund this agency. And hopefully, through the appropriations process, over the years, they've had some bonuses, one-time shots. In the base bill, there's probably 5-10% pay raise across the board for state employees. But my goal would be to encourage our Article 2 folks, and I know Chairwoman Rose is very familiar with this work and her work in that committee, that we need to pay these folks. And also, if you were surprised, there's no fiscal note to this bill because we're talking about caseload goals. And so some of the things that they can do in the bill can be done with existing resources. And so I know that we probably have some witnesses here to testify, but I'll be glad to answer any questions that the committee might have, Mr. Chairman. I appreciate your work on the committee because I know you're passionate about this issue as well. And we've had, Frank
discussion. Boom, boom, boom.
discussions about caseloads and what
Some
a
people are
case
just
means.
getting that, by the way.
Yeah.
A little,
It's
kind of
8 o'clock.
bounced through the
It's
room.
8 o'clock.
but-
So I appreciate the opportunity to serve with you guys and look forward to working with this committee on this bill.
Yeah, thank you very much, and appreciate the bill. And the one thing that's not in here, and I don't think, is the definitions of what a caseload is. And this
Correct.
is something that we have discussed at length, and I'm going to ask because I do think this is an important topic, and it's kind of nice to discuss it now because, honestly, if you look at it, we're within and sometimes very much below the caseload limits that are in here. And so I think it's a good time to kind of relook at this.
Correct.
I think when you look at it from a 20-year picture, there's been a lot of money put in. Caseloads have come down almost every session. Whether they're at the right number or not, that's something we can discuss. But I appreciate your focus on that. How did you? So there's different numbers for each caseworker, right? Or for each type of caseworker. I'm sorry. Where did you get the differences in those from which report? The caseloads are really, to me, they're an interesting thing to look at and something that we ought to again discuss because. Like, for instance, with investigations, how long an investigation drags on will change the caseload, right? Like, if you never close an investigation, you can have 100 caseloads. Whereas the conservatorship side is much more straightforward, right? You either have the kid in conservatorship or you don't. And to me, that caseload number is very meaningful and can't be manipulated that much, it doesn't seem like. But where did you come up with the different numbers for the caseloads?
Part of the rationale was just all the reports. So you have so many reports.
Yeah,
You have
yeah,
the-
Stevens.
you have the
Yeah,
lawsuit.
there's tons. You're
There's
right.
tons, and
Okay.
trying to average those out. So there was no science to it. Look, we do
Okay.
public policy.
Yep.
So
Yep.
we tried to take averages of these cases. And so it wasn't,
Okay.
well, you need to have
Okay.
this number. So when you read the bill, it talks about, even though the language in the bill says shall, it says shall work towards ensuring
Right,
that
yeah.
the average, right? So we had to be very artful in the language
Right.
in the bill so that, yes, it sounds like a mandate, but also give the agency some flexibility. And there's really no, hate to say it in these terms, but there's no penalty, right, for not
Right.
reaching them.
Yeah.
Because what we want to do is have it in writing,
Right.
that we can reach these goals. And so I think it was just more of an average of the ones
Okay.
from the different reports. So
And I think
if we have suggestions from the committee, always open to working with the
Well, I think
committee.
one of the things I really would love to do is to sit down with the agency and you, and because I think one of the things that needs to be added in here is the definitions
Right.
of
Yeah, and
what
we talked about that a
what a
couple
case is. And I'm gonna call the resource witness on this because, we have 20,000 kids in foster care. We have almost 2,000 caseworkers. So do the math in your head real quick. 20,000 kids, 2,000 caseworkers, yet our caseloads are showing at 20. You can't do that in your head. It should have been 10. 20,000 caseworkers, or I'm sorry, 2,000 caseworkers, and I'm rounding, But
and this is
somehow it's 20. And so I think we have to define what a case is, because that's not, the data is not great. And I think that it is important that we have better data. And I think it's something that the agency, I've talked to the new commissioner about it. I think she understands the problems of getting data that is meaningful. And I think that's something, I think it's an important task, and hopefully we can get some progress on it.
Yeah, no, I agree with you, and if there's the ability to do some type of definitions here, I'm open to it.
Yeah.
I would just also add, in working with caseworkers, you have caseworkers that are having to sit in court, right? And so even though you might have 10 cases, let's just say you even have a goal of having 10 to 20 cases, you're sitting in court. You're having to wait for the county
Absolutely.
attorney's office, because that's who represents DFPS in Harris County.
Yep.
And I'm sure it's that way in most counties. They're having to wait.
Yep.
And they don't just have 10 cases, right? They'll have multiple
right.
cases, and I'm sitting next to them, waiting to be called up by the judge, because some days are adoption cases or days, and those are good days. Those are happy, crying days. I've been to those, and those are very emotional, great days.
Absolutely.
But I've also been there with some serious allegations against folks,
Yep.
and it makes you angry. I have two boys, 12 and 9, and most of you guys that have, I mean, nobody, it doesn't matter if you don't have children or not. Nobody wants to see children in this situation, but they are.
Yep.
And having to sit there and listen to these allegations and read these reports of these children, and I've done home visits. I'm sorry. I've worked with caseworkers. You know, they're working their tail off, trying to get to places, traveling far to get to places, sitting in court for hours on end, waiting to be called, and then trying to do the day-to-day administrative work.
Not an
So,
easy job.
It's not an easy job. So that I just want to give some context in that framework, just from my experience working in the field.
Thank you very much.
Thank you.
Members, any other questions?
I have a question.
Yes, Representative Ramos.
And I don't know if you can answer this, Rep. Wally or Frank. What is the average? Is the average caseload now 20? Is that the average caseload, or, I mean, I guess it
I would
varies.
defer to the agency.
Okay.
Yeah, and we'll get the resource witness up. I think, to me, one of the most important things is realizing in caseload, it's totally different based on the worker and the stage. Like,
Yeah.
what an investigation caseload is totally different than what a conservatorship caseload, which is different than what a FBSS caseload is. And they all move, and that's why I do like the way the bill's laid out it's different based on different cases. I do think, especially with investigations, how long something, if you just put it on the shelf, that's a case, whether you're
But
working or
sometimes
not. There need to be processes in addition to caseload numbers, which is where I think the definitions come in to play.
And just to add a little more context, you can't keep that case open, right? I mean,
Yeah.
they'll going through that process. At some point, you're going to have to close it out, or there's undetermined.
Yeah.
The confirmation of a confirmed abuse, abandonment, or neglect. At some point, you have to close it out.
Well, and I love that it's aspirational, so it's aspiring to these goals. My question is, could the agency have implemented this without legislative action? Okay, thank you.
Yeah, of course.
Right.
Yeah.
And look,
And at the,
we applaud the agency for making strides, right? It's not, they've been through our committee.
Yeah.
And it's not an easy job, and we've had a lot of turnover. And so that's another issue that we need to work on.
Well,
to retain these folks.
and at the end of the day, the agency can only hire what they're appropriated for. And so you can put whatever goal, if it's not appropriated for, it doesn't matter, right? So, but I do think having more, and I think one of the things, just the more discipline and more processes in the agency it will result in better outcomes for kids. And I think it's a good time to look at it now, because caseloads, by and large, at least on the custodial side, the investigative side is still going just as fast, but the custodial side is much slower. And FBSS caseloads are way down as well. So I think it's a much easier time to look at it, because you're not pushing into the appropriations challenge. So Sorry.
Thank you, Chairman.
Need to, Thank you for bringing this, and we'll certainly have you close.
I'll be right here.
All right. There is one witness, and then I am going to call the resource witness, but I'm going to first call Christy Carrington from the Texas State Employees Union testifying for the bill. I show nobody else other than the resource wanting to testify on this bill, so get signed up if you're planning on it. Yeah. And if you state your name, who you're with, and your position on the bill, please.
My name is Christy Carrington, and I am representing Texas State Employees Union, but I have retired from CPS. I worked as a caseworker, and I also worked as a supervisor. I worked actually in FBSS. I worked at the Children's Assessment Center, at the Advocacy Center. So primarily I work sexual abuse units.
And are you speaking for yourself or for the union or both?
Well, I'm speaking for myself.
Okay, and your position on the bill?
I am for the bill.
Okay, thank you.
So I've worked in the Advocacy Center. I've worked very closely with investigations, CVS, courts, all of that. So I'll just go ahead and read what I've written. And just so you know, prior to me coming here, I spoke with investigations last night, and this is my information is very, very current. So the FPS investigations, and I'm going to focus on that because right now it is in crisis, is significantly understaffed and is currently facing a potential mass exodus of caseworkers, supervisors, and tenured management. As caseworkers have left, the average investigative caseworker today has a caseload of 40, not 20, 40. There is intense pressure from upper management to get caseworkers to close cases in order to make the data reports look good. The unrealistic expectation results in punitive measures such as mandatory overtime in order to keep the cases down. Now, supervisors have to work that overtime as well, but supervisors don't get paid. This leaves caseworkers and supervisors exhausted with little to no work-life balance. All staff work truly 10 to 14-hour days to get all of the work done. This includes weekends because of on-call schedules, CWAP, and all of that. To be clear, this negatively impacts child safety and hurts the families we serve. Exhausted program directors, exhausted supervisors, exhausted caseworkers make poor decisions. They miss crucial elements while in the field. Children die or remain in unsafe homes, and families do not receive the intervention that they need. The typical day of a caseworker, and this is very important because there is the data and then there's the day-to-day of a caseworker, and it changes. You make your plan and it changes based on the day. So the typical day of a caseworker and supervisor includes mandatory trainings, mandatory meetings, mandatory on-call schedules. You have mandatory contact times with families, particularly in investigations. Families don't just wait there for you. You know, you can go to the schools, hopefully they're there. You know, a lot of times families will pull kids out if they know that there's an abuse call on them. You don't find them timely. Sometimes it might take you all day, 2 or 3 hours. You have mandatory conferences. There's court. There's the things that come up, and then there's the documentation and all of the normal stuff that you have to do. Caseworkers receive, in addition to their cases, they're receiving 6 to 10 cases per week. Supervisors have to read and assign these cases. Supervisors also have to read and close cases. Caseworkers are required now, because they're trying to get the numbers down, to close 2 cases per day. So it takes at least 2 hours to fully document, call your collaterals, do everything you need to do on the case. And still, you have your contacts to make and your other families to see. You have to make regular contacts with all of your open cases. Depending on the case, it can, like I said, it can take all day to make a contact. So reaching the goal of a reasonable caseload standard is not a quick fix, and it is very complex. There are a lot of moving parts. But the goal of this agency, and I'm very committed to DFBS, the goal of the agency is to help families and save children. And we have to support the workers in order to support the families. So it was already been mentioned about CVS and the caseloads with CVS and everything that happens with that. But the caseloads, even though it should be 14 to 17, the recent information that we've received is that they have gotten as many as 22 to 29. So there's always been this. There's what's on the ground, what happens in reality on the ground. And as caseworkers, we would always say we would like for people to come and do ride-alongs, come and actually be with a caseworker, not just for, the morning, just a good week to see what happens day to day with the caseworker and managing this job. So thank you for supporting this bill. I'm definitely for it. And Yeah.
Thank you very much, ma'am, for your testimony and your service to the kids of Texas. Members, any questions? All right. Thank you very much for your testimony.
thank you.
Chair calls Erica Benuelos, resource witness, DFPS.
Good morning.
Good morning.
I'm kind of short. Okay. Okay, it doesn't want to work with me. I'm going to move here.
All right, thank you very much.
Good morning.
We show you registered Erica Benuelos, DFPS is resource witness, is that right?
Yes, that's correct.
All right, thank you. On the bill.
Yes. Well, yes, I'm Erica Bañuelos. I'm the CPS Associate Commissioner, and I'm a resource witness.
Okay, thank you. I think Vice Chair Rose has some questions.
Hi.
Or did you have something you wanted to lay out first?
Well, I do have Marta Talbert with me since she is the acting over investigations. So I'm assuming that you all will have questions on both. And as you mentioned, Chair Frank, there's just a different calculation for CBS, which is larger, and then there's one for CPI. So if we could bring her up here, I think that probably would work.
Okay, why don't we do it one at a time?
Okay.
That's okay, unless we need to. So Vice Chair Rose?
Thank you. I've been on this is I want to say my sixth session on this committee. And I believe Chairman Wiley has been bringing this bill for all 6 of those sessions. And every year when we have appropriations, we give money. Every year we just give money, more money. And I'm just trying to understand, what is the problem that we can't resolve this issue? It shouldn't take us coming in here legislating the agency to make sure that these caseloads are not high. And so could you just explain to me what is the issue and why, the cases can't, have low case loads? And I understand the turnover. And then we put more money in for new employees. I'm just at that point this session. What exactly is the problem?
Yes, so for conservatorship, and Chair, Vice Chair, I've been a worker, so I've carried the high caseloads.
I have too.
And I can tell you that we are in a much different space than we were in the past, and a lot of it is very thanks to you all for what has been appropriated for us. And our workloads in conservatorship actually are very low. Right now, our average caseload for conservatorship is 10.8. We have 92% of our caseworkers have an average, they have 17 or lower children on our caseloads. So we have made significant progress. For FBSS, the caseloads were very low, and they are picking up. So now we're up to an average of 7.0. So we are definitely have worked towards bringing down those workloads for staff in conservatorship. And what we see is that we do have the amount in CBS, in conservatorship, we have the amount of workers that we need to lower them even lower. And we look at turnover, but an important piece that's not talked about a lot is the case carrying rate. And that means that if my turnover for example, in FBSS, I have a 21% turnover, right? And I have only 93 vacancies. However, my case carrying rate, which means that I'm a worker that can actually work a case, is only 79%. So I know that you were asking, what is the definition of a caseload? Because it can be very confusing, and I feel like I need a whiteboard to go through it with you, Chair.
I feel like I need one as well, because I
Yeah.
met with somebody very high up in the agency less than a month ago, and the number was 19.9, and then today you're testifying at 10.8.
Right, so it
Okay,
moves
that's-
day to day.
That didn't move day to day. That was a conservatorship. Doesn't move from 19. It does move day to day. It doesn't move from 19 to 10 or to 11 in a
Okay.
month.
Oh,
It's just
okay.
different numbers. And that's where I do think, Representative Wally, if we can define what a case is and be consistent from report to report, and this has been a consistent, a challenge to me from a member standpoint, getting consistent, accurate information. And I do think that's the first time I've heard of 10.9, and my jaw almost dropped when you said that. Because that, to me, is the math, right?
Yes.
It's like, from the big picture standpoint, I know there's some people that can't work, but still,
Right, so a caseload,
that aren't ready to work.
yeah, a caseload is defined for us as somebody who's carrying a primary case assignment. So any primary cases on a workload on any day today,
Right.
right? Anybody that has a primary workload assigned to them is going to go into that average daily caseload. And it's also dependent upon whether or not, and how they look at it is, do I have a worker taking cases full-time? Do I have a worker taking caseload half of a time, right? Because we know caseworkers, even though I hire them, they're not fully case assignable until 6 months. So there is a formula to it, and it can be really confusing.
But that's what I think we need to, I don't know whether we need to put it in statute, but we need to be consistent with with the information that I think we're
I
being
agree.
given, because sometimes that caseload also includes the parent. And when most people think caseload per worker, you're thinking of kids, right? You don't,
Correct.
because some of those kids will have you have 4 kids in the same, which is easier, obviously, than 4 separate cases. But I don't know, we think of it caseload per a child per worker.
Yes, CBS is a little bit more confusing because you have a child, right? Each one of those is a stage that gets counted on a worker's workload. And then the worker might also have an FSU stage, which that's the parent stage. And that counts as one stage as well. And then you have kinship. And kinship is, it's one case per household. So if I have a grandma and a grandpa living in the same house, taking care of 2 kids, that's one case. But if there's a sibling of 4 groups and one is placed with grandma and grandpa and one is placed with aunt and uncle in a separate household, that's another case. So yes, there's a variation, and I agree. We can sit down and we can work out, what is the definition and how do we look at our state?
But I do think from a department standpoint, I don't know if y'all have it, but providing how you're calculating caseload for each of these, because I do think he's got it exactly right. Each of these caseloads and the caseload you should carry depends a lot on how much is involved in the caseload, because they're not,
Absolutely.
we think of caseloads as the same. It is not. You don't do the same work in each of these stages. So do y'all have that right now, a definition of each, of how you're arriving at the math?
Yes, we do.
Is that something you can provide to?
Absolutely. We can send it.
And is that coming from federal regulations, statute, or rules internally that y'all have produced over time?
So we know that we have an LBB to meet. I don't know that
Or LBB set, that's right.
Yes, they're already
LBB
set.
definitions.
Yeah, they are set. And so I believe you set FBSS at 9.3, and we're at 7.
I meant the way you calculate them, not the numbers, but like
okay.
what's going into the numerator, what's going
Yeah.
into the denominator, what you're actually counting, I think is something that needs to be understood by here. So if we could get that, that would be awesome.
Absolutely.
And then do y'all have consistently can y'all provide like 10-year timeline or whatever is the best range of, in each of those categories, here's what caseloads have done in each of these categories, and here's the way we define, and hopefully consistently across that time. And I don't know, it doesn't have to be 10 years. I just think whatever y'all haven't done a system change, so that,
Yes, we can get that for you. That's not a
okay?
problem.
Because I think that would be, Because, and one of the things, and I know Chair Rose and I, and both are frustrated, that the reason that we hadn't been able to do the bill, frankly, is if you mandate a low number and there's not money for it, you just can't get, but the conversation is a good one, and I think, to me, I think now is the appropriate time to try to get it done. Yes, Representative, I'm sorry, you done?
You didn't answer some of my questions.
Thank you, Mr. Chairman. I have a,
Representative Noble.
thank you, Mr. Chairman. I just want to touch on something that the previous witness spoke about, and that is how much time is eaten up in things that we've done, such as mandatory training and mandatory reports. And I want reporting. I mean, we need that, right? We need to be able to see what happened along the way. I'm not talking about that, but what red tape have we put in the way that eats up time that they could be spending on the children and on really moving the ball down the road? And so that's just something that I personally would like for us to look at as well as we look at these caseloads. And if it is us that's causing those caseloads to be higher than they need to be, then please report that back to us, because I think I speak for all of us that we don't want busy work. We want significant work. So anyway, just would you let us know what those mandatory trainings, mandatory meetings, and conferences, what do those look like, and are they necessary?
Thank you,
Thank you.
Representative.
Okay. Any other members, any other questions? All right, thank you very much. Who is it?
She does CPI.
Okay, but it's Marta Talbot, right? Yeah. Okay, Chair calls Marta Talbot with Child Protective Services. If you'd state your name, who you're with, and your position on the bill.
Good morning, I'm Marta Talbert, and I'm an Acting Associate Commissioner for Child Protective Investigations. So I cover all the investigations and alternative response, as well as child care licensing at this point.
All right.
Resource
Members,
witness on the bill.
yeah, members, any questions? Okay, thank you very much. So from a CPI, how long, what's the average length of investigation?
So we should be submitting them in about 45 days, but I will tell you right
I'll
now.
say we should be. What's the average
I'm
length,
gonna
not
tell
what we
you.
should be.
Right now, we are about 19.8%, where we're 60-plus cases. So we have an average of about 5,000 cases over 60 days in investigations at this point.
I kind of lost the numbers there.
Yeah, so about 5,000 cases that we have over 60 days, and our percentage for 60 plus is about 19.8%.
So 20% of the case.
Go ahead.
Wait, 80% are going longer than 60 days, or 20% are going longer than 60 days?
20% longer than 60
Okay.
days.
So what is the average? Do you know that number?
The average,
The average length of case?
no, I don't have that.
Okay. And your average or your case load? So you've got roughly 2,000 investigative caseworkers?
I have right around 2,700 investigation caseworkers, and right now their caseload is about 14 currently. We're about 45% turnover and about 68% case carrying.
Okay, thank you. Members, any other questions? All right,
Okay.
thank you very much. All right, at this time, there are no other witnesses signed up to testify. Is there anyone else wishing to testify on, for, or against House Bill 2359? Seeing none, public testimony is closed, and the chair recognizes Representative Wally to close on House Bill 2359.
Thank you, Chairman Frank and the committee, for the discussion, and I'm sure we will continue to have this discussion as the session moves quickly.
Moves quickly.
But would love your favorable consideration, and if y'all have any input on what we can add to the bill, always open to that. I've been here long enough that as you file a bill, it doesn't come out as sometimes as you intended it, but hopefully the meat of it still stays intact. So thank you all for your time, and I know you have a busy day, so I
Yep.
close.
All right, thank you very much, Representative. If there's no objection, House Bill 2359 will be left pending. Is there objection? The chair hears none, and House Bill 2359 is left pending without objection. Okay. Chair lays out House Bill 1990 and recognizes Representative Wu to explain his bill. You all right there? Oh. You need do we need to bring you a chair, Representative?
No. gardening accident on the weekend. It's old man pains.
Gardening accident. I didn't hear what you said. Gardening accident.
Dealing with all the dead plants I'm after.
You need to work on a better story. All right.
Bar fight. Thank you, Chairman Frank. And this is a very simple bill. This is more or less the result of basically there was an incident, I think that happened in Harris County, where and it made the news where there was a case where the family ended up suing the department and saying like, hey, you guys went back and lied about stuff that happened in the case, and then it was found out that, you know, there was some post after the fact changes made to the report that sort of like changed what the story was and all this other stuff. And I'm not going to get too deep into that, but essentially, like last session, I carried a piece of legislation that basically said, hey, don't make changes to reports. And in response, and this is a lesson for you members, is and CPS really didn't like that bill, so they dropped like a $3 million FISCO note on it. And so that didn't go anywhere. So I'm trying to take a different tact this time. This legislation just says, well, let me back up a bit. So in a CPS case, there is what we call the narrative, right? The narrative is basically the story that is told about the case, of why the case came in, what the initial report was, what the initial witnesses say. Essentially, it's like, if you want to think about it this way, is like if this was a criminal case, it would be the police report. It would be what we call it the offense report. And it would be the main statement of, I started the investigation on this day. I talked to this person. This person said X. And then I went to talk to these people. And then I talked to these witnesses. And then we did this investigation. We did we did a drug test. We did whatever it is, right? And that's the narrative of how this happened. And so that narrative is a part of the greater case file. And so the greater case file can have lots of other stuff in it. I don't care about the rest of the case file. I only care about the narrative, because the narrative is what the entire case is built around. So when the attorneys want to have a fight about, ultimately, if we go to trial and we have a big fight about what actually happened, all the stuff, the narrative is the backbone of what we're fighting about. And if there are any changes to the narrative, it's pretty significant, right? And the situation that I could see that would come up like all the time would be something like, the narrative would initially say there was an allegation of drug abuse by one of the parents. And even though the case is mostly about mental health and possibly physical abuse and all this stuff, there's like, well, there's an allegation of drug abuse. And throughout the case, everyone's like kind of fighting over it. It's like, there's no drug abuse. There's no drug abuse. There's no allegation. Who said this? And trying to figure it out. Ultimately, they go back and say, well, okay, we went through it and we double-checked stuff. Supervisors went through the notes and stuff and said, like, look, we said initially we thought there was an allegation of drug abuse, but it turns out there's not. We're going to go back and change it. Okay? That's a really significant change. That's a big change. And all this bill says, look, if you go back and change the narrative and change what your statement is on what the initial investigation was, just let everyone know. That's it. Just let people know. Let the attorneys know, let the parties know, and then whatever happens, happens. Right? That's it.
Okay.
The end.
The end.
Right? No fiscal note this time.
No fiscal note. Well, and in my recollection, not that we can talk about prior bills, but that if you, there was a system limitation because the system is quite old.
Yeah,
and so I think it was more of the technical change, and I think it is something that, and this is something to talk to
they would have
the new commissioner on.
And all this other stuff.
We have to get a new system. You can literally make a change in the system, and it doesn't date stamp it.
Yep.
That is dangerous on a bunch of levels, and so.
Well, the good news is that that the appropriations, I said on, there is money in for revamping the impact system.
Well, I think that's been done twice and not implemented either time. So you can give money, you still have to execute the
Right.
implementation.
It's going to take like 7 years.
Right, yes, so, all right, members, any questions? Yes, Chair Clitt.
When in healthcare, when the narrative or you find out information later that was either new information or contradicts,
Right.
some type of confirmatory evidence, we do late entries. Is that what you're speaking of?
No. So they literally, if there is a report and somebody goes back and changes, all these, the changes and the initial reports and the changes all have to be approved by supervisors, right? And there are situations when, they have a report and somebody's name is spelled incorrectly, or the wrong name is used because they thought that person's name was X, but it's actually Y, and then they have to go back and change the names. Those things happen. They get approved by the supervisor, and those changes, in my experience, at least in the decade I've been taking these cases, are relatively rare. Because usually they're pretty diligent about, the FEPS is pretty diligent about making sure the initial report is correct as best they know. But if there's needed to be changes, it still has to go through the same reporting process, has to be checked on by supervisor, and it's not like there's no note, because that's what we had asked for last time. Like, can you leave us a note that a change was made and stuff, and that would have caused a whole big reporting. A physical note for changing the system. This is still using the system they have in place right now. Right, that doesn't make them add anything to the mechanism of the report of creating the report. It just says, just let us know. The way I would envision this is the county attorneys usually represent the DFPS, and the county's attorneys would just send a memo out to all the parties saying, hey, and submit it to the court. It says, hey, FYI, the report was updated, and on page 3, we changed this word to this word. Right? That's it. Right? Or even, and the bill does not say what you have to tell what the changes are. Like, if you just, as an attorney, if you just tell me there were changes in the report and I get a new copy of the report, I can
Find
read
them
through it and
yourself.
figure out what the difference was.
Okay,
Right?
thank you, members. Any other questions? All right, there's nobody showing to testify, but I'm going to call Marta Talbert, DFPS resource witness. I show nobody else wishing to testify, so if you're wanting to testify, please register.
Hi, Marta Talbert, resource witness on the bill.
All right, and so in terms of implementing this, this is not something we do currently? We make changes and don't notify legal representation?
I don't know necessarily that we have it currently in policy, but I will say, yes, we should be notifying if there's a significant change, right? And let me kind of back up. Once our investigation, let's say, is closed, we've topped it up, it's actually closed in the system. We now have to either open it back up, which it would show the time and date that we open that case back up to change anything, or we have what we call a closed stage addendum. In either of those type cases, if we have legal or parents legal involved, we should be notifying them. I think it's just kind of an add to the policy. And I will agree, we were thinking, it's an impact change and we need to do this drop down. And then my staff met on this bill, and we feel like this is more of a policy, just education of our staff, making sure they understand and notify, those kind of things to be very clear in our expectations to make sure if something's significant, to please notify the parties in the case.
Well, are we going to be, I don't read this as something significant. I read this as if there is a change, you notify. Because you start saying significant, that gets very subjective.
Yes, based on this bill, you're correct. I think it was with my staff meeting on this bill that kind of some of that language was more about significant contact, not if we misspell a word and we change it, or you know what I'm saying? Like every little change, would we really notify the parties, or if it's something like there's allegations of drug use, and then
Right.
we find out it's not, that we make sure we notify that we documented and changed.
Well, I guess I would just ask, make sure there's feedback, because we sort of want you to follow the law as passed,
Absolutely. we
not
will.
as
No,
you feel. And
Yeah.
so if it needs to say significant, I'm not saying it does or it doesn't, but if it's passed that you make a change, if you change a period, you need to do that. And
absolutely,
if,
we
and
will
if,
follow.
and if we need to change that, then I hope you would have some communication with the bill author. But I would be worried to have much latitude with the word significant, personally.
Yes, and I think we,
I don't, people
think
really go
that's-
back and add periods or change misspelled words? I don't think so, but maybe they do. Okay.
Yes.
Members, any other questions? All right, thank you very much.
thank you.
At this time, there are no other witnesses signed up to testify. Is there anyone else wishing to testify? Cracking me up. Is there anyone else wishing to testify on, for, or against House Bill 1990? Seeing none, public testimony is closed, and the chair recognizes Representative Wu to close on House Bill 1990.
Thank you. One small correction I guess we could probably make to it, if it's a problem, is we can add like a material change, right? And I know significant, there's a question of
Yeah.
like what significant means, like, but we can say like material change, meaning like it's not something outside of grammar, right?
Yeah, I just don't believe in a lot of latitude in these, because to me, to me, from an agency standpoint, and I think the agency does a lot of great jobs in a lot of areas, but processes aren't always there. And I think the less wiggle room, the better on that, but it's your bill, and I'm not, you work in this area a lot more than I do, so,
We can definitely talk about it, but
yeah, I just be clear with whatever you do. All right. So
Thank you.
Close?
I close.
All right, thank you very much. Is there no objection? House Bill 1990 be left pending. Is there objection? Chair is none, and House Bill 1990 is left pending without objection. The chair lays out House Bill 1167 and recognizes Representative Romero to explain his bill. And I understand that you have changes made to this bill. I'm sorry. We do not have the substitute before us, so if you have changes that you're going to make, you can talk about them, but we have the original bill before us.
Thank you. Thank you, Chairman Frank and committee members, for the opportunity to lay out House Bill 1167. As each of you serving on this committee well know, Texas is facing a shortage of mental health professionals, and this shortage is expected to worsen in coming years as many of our state's most skilled practitioners near retirement age. Right now, over 95% of Texas counties are designated as mental health professional shortage areas, and that's a 15% increase from the previous year. We must find ways to increase Texas' workforce of skilled mental health professionals, and HB 1167 seeks to do just that. This bill will facilitate licensure reciprocity for mental health professionals who have moved to Texas. It will update standards to expedite administrative licensure processes for experienced marriage and family therapists, professional counselors, and social workers. They will be required to have completed supervision hours in their state of origin, be in good standing with their licensing authority, have practiced independently prior to the application in Texas, and also need to pass a jurisprudence exam here and pay appropriate licensing fees. This bill is supported by the Texas Association of Marriage and Family Therapy, Texas Counseling Association, the National Association of Social Workers, among others, and it was also unanimously passed by both this committee and the House in its identical form last session. Daryl Spinks, the Executive Director of BHEC, the Behavioral Health Executive Council, is here today as a resource to answer any nuanced licensure questions.
All right, thank you, members. Any questions? All right, thank you for bringing this, and we'll give you the right to close. We've got a couple witnesses. Chair calls Leila Anderson. And then Jan Freese is on deck. And we show you Leila Anderson, Texas Association of Marriage and Family Therapists, for the bill. Is that correct?
That is correct.
All right,
Thank you. Good morning, Chairman Frank and members of the committee. I am representing the Texas Association for Marriage and Family Therapy, as well as myself. As a marriage and family therapist, supervisor, and licensed chemical dependency counselor, I am the executive clinical director of Ava Recovery Center near Austin. I supervise marriage and family therapists. I support this bill because I've been doing this work for about a decade. I know that when I first walked into my graduate program and saw like the stack of forms I was going to have to go through to actually finish this process, it was incredibly overwhelming. And thinking about other people who really want to be providing mental health services to people in Texas, I want to look at ways that we can remove as many barriers as possible without compromising the quality of what we're doing in any way. I think that bill accomplishes that. I think that in response to the Uvalde report, I think this does a really good job of expediting the process from a bureaucratic standpoint to get people fully licensed without compromising training quality. I'm a trauma specialist. I work in chemical dependency, which is a pretty high risk area to be working. I want people trained really, really well in what they do. I don't want to compromise that at all. I think that this bill lets us clarify some processes, lets us make sure that experience that people have is being counted in ways that really make sense, that is productive. And I think what we've learned is that the quality mental health care saves lives, and that the more we have quality mental health care, the more we're able to provide services that help people be healthy, be productive members of our state, work together in more ways. That's all really beneficial to me. I also appreciate, just as a therapist and as a supervisor, I appreciate the precision of the language in this bill. I think that there are things that were unclear in some of the original, the way that I look at the board rules and the statutes. I think this clears up some things. I don't think this is making, from my standpoint, a bunch of super significant changes to most of what it means to be a marriage and family therapist in this state, but I do think it expedites processes in ways that are really beneficial. Also thinking about people moving from out of state, if we do have people who are associates, people who are coming in, people who are looking for a Texas license, and they're already qualified or they're already really close to becoming qualified, I don't want to throw up barriers in people's way just because. I think we need to have good reasons for any barriers or any gatekeeping that we do. I think this eliminates some of that. So I do support this bill. I want to thank you for the opportunity to testify in favor of it. I want to thank Representative Romero for bringing it, and all of you for your consideration.
All right, thank you very much. Members, any questions? All right, great job. Thank you. Chair calls Jan Freese. I hope I got that right. I show nobody else wishing to testify. So we show you as Jan Freese with Texas Counseling Association for the bill. Is that correct?
Correct.
Okay.
My name is Jan Freese.
Freese. Okay.
I represent the Texas Counseling Association. We represent over 7,500 professional counselors in an array of settings across Texas in support of this bill. And thank you very much for bringing it back. This bill doesn't create any new licenses. It's a technical cleanup bill. Last session, it flew out of here unanimously. We got on local consent, flew out of the House, and we got all the way through Senate, got on local consent, and then sort of got stuck in that kerfuffle at the end of last session, too.
There's a few of those.
Chairman Burrows. It will expedite the approval of other mental health professionals licensed in good standing in other states. It's going to reduce the amount of time to get those people active and involved here in Texas. It makes some technical corrections. When BHAC was created 2 sessions ago, it was like a 100-page bill because it had all of our occupational codes, so we're fixing some technical issues in there. For LPCs, this is really important. It changes for our associates, it changes them from a temporary license because they are fully licensed and completed all of their training except 3,000 hours. So it changes their license to an associate license, which is what we currently call them in rule now. And it has no fiscal note. So I hope we have the same experience with this bill this session as we did last session, and I appreciate your hard work, and thank you for your support.
All right, thank you. Members, any questions? All right.
Thank you.
Thank you for your testimony. At this time, there are no other witnesses signed up to testify. Is there anyone else wishing to testify on, for, or against House Bill 1167? Seeing none, public testimony is now closed, and the chair recognizes Representative Romero to close on House Bill 1167.
At least it wasn't Ramirez.
Well,
Thank you, Chairman Frank and members. I mean, I couldn't said it best with the witnesses. I mean, I think that to say quality mental health care saves lives, that this bill helps therapists become more active and involved is enough said. So thank you, and with that, I close.
all right, thank you very much. If there's no objection, House Bill 1167 will be left pending. Is there objection? The chair hears none, and House Bill 1167 is left pending without objection. All right. The chair lays out House Bill 12 1287 and recognizes Chairman Guillen to explain his bill. Did you get your constituent all taken care of?
Yes, sir.
All right, very good.
Thank you, Mr. Chairman. Members, Chapter 33 of the Human Resources Code lays out the framework for the Texas Supplemental Nutrition Assistance Program, or SNAP, to provide food assistance to eligible low-income households in Texas. To receive SNAP benefits in Texas, families need to meet income and resource limits. Current law exempts a family's primary vehicle up to a value of $15,000 and $4,650 for an additional vehicle. Any vehicle value that exceeds these amounts aren't exempt and count towards the household's resources, which results in the reduction or elimination of benefits. The current vehicle asset limits have not been updated since 2001 for a family's primary vehicle and since 1974 for an additional vehicle. These limits have obviously not kept up with the rate of inflation, especially as inflation has skyrocketed over the last couple of years, which has caused many families to lose their SNAP benefits. To help address this, House Bill 1287 would allow the Executive Commissioner of HHSC to adjust the maximum fair market value of a vehicle annually to reflect the percentage difference between the average index level set by the Bureau of Labor Statistics and the new vehicles index of the Consumer Price Index for all urban consumers. Members, it's only fair and just that asset limits for this program reflect current market values and current economic conditions. We are working with stakeholders on a sub to refine the mechanism to allow vehicle asset limits to be adjusted moving forward. I can help answer any questions, and I believe we do have some witnesses here as experts and resource witnesses to help answer any questions.
All right, thank you. Members, any questions of Chair Guillen?
It's a good Democratic bill.
All right, thank you very much. All right, Chair calls Grace Norman, and then David O'Neill is on deck. We show you as Grace Norman with the Baylor University's Collaborative on Hunger and Poverty for the bill. Is that correct?
That's correct.
All right, go ahead.
Chairman Frank, Vice Chair Rose, Chairman Guillen, members of the committee, thank you for the opportunity to speak with you today. My name's Grace Norman. I serve as Chief of Staff at Baylor University's Collaborative on Hunger and Poverty, or BCHIP. BCHIP leverages a combination of policy, research, and programmatic work to address food insecurity in Texas and across the country. And we support House Bill 1287 because by adjusting vehicle asset test limits, Texas signals it values those living in rural areas equal to the extent we value those living in urban areas. The outdated vehicle asset test limits trap many Texans in an impossible catch-22. If they sell their car to comply with the asset test, they can no longer commute to their jobs to meet SNAP work requirements. If they keep the vehicle so they can get to and from work, the vehicle asset test combined with their liquid assets disqualifies them from being eligible for SNAP. This issue is particularly important in rural areas where a personal vehicle is often the only reasonable option for commuting to work, shopping at a food store, or receiving medical care. Under the current law, nearly 55,000 Texans can be denied food assistance simply because the value of the vehicle was pushed above the threshold by inflation. At a time when food costs, like the value of used vehicles, have increased due to historic inflation, you have a rare opportunity to make a small but significant change to ease the economic burden on these families and protect them from food insecurity. Thank you for your time, and I welcome any questions.
Thank you very much for your testimony. What is the value in the bill? Because it's not laid out. So what is the value of the car that is allowed?
I will defer to some of the other witnesses, but ultimately in line with inflation.
Right, but what's the starting point? So we'll ask others. Okay. Okay, thank you. Members, any other questions? Yeah, I saw that, but I may call the resource witness. So thank you very much. Members, any other questions? Thank you for your testimony. Chair calls David O'Neill, testifying for self. David O'Neill from the great city of Wichita Falls. Worked with him.
Absolutely.
Yep. I show you David O'Neill testifying for self and for the Wichita Falls Area Food Bank for the bill. Is that correct?
That's correct.
All right.
All right. Good morning, Chairman Frank and members of the committee. Thank you for the opportunity to speak on this bill. My name's David O'Neill. I'm the acting CEO of the Wichita Falls Area Food Bank and a member of Feeding Texas. The mission of our food bank in Wichita Falls is to unite our communities to fight hunger with food education and advocacy. Our food bank serves a 12-county area and works with over 180 partner agencies to provide food and nourishment to our communities. We offer emergency food distribution, nutrition education, help people apply for SNAP and other benefits through a partnership with Feeding Texas and the Texas Health and Human Services Commission. We also supply snacks to senior centers, daycare centers, after-school programs, and administer the market nutrition program for seniors and new moms. The food insecurity rate in our service area is over 16%. It's one of the highest in Texas. And 1 in 5 children live at a risk of hunger. Our communities have been obviously hit very hard by inflation. People are struggling now more than ever to put food on the table and pay their bills. As a result, what we see more of our neighbors at our mobile pantries who need assistance. Many are on fixed incomes, but those who are employed are also seeing that their earnings just don't go as far as they did in the past. Many of those that we served were impacted during the pandemic and are still struggling to get back on their feet. As a rural food bank, we face distinct challenges. We have to pay more to feed each person than our larger urban counterparts do because we're located in what's called a food desert. To reach the people in the most remote parts of our service area, we have to do mobile deliveries to towns like Haskell, Seymour, Electra, and Throckmorton. So the increase in transportation costs has really forced us to do more with less. What I can assure you is that our food bank does everything we can to meet the increased volume and requests for emergency food. But we do, as I mentioned, face significant challenges ahead of delivering close to 5.4 million meals that will be needed to be met this year. That's why I'm here today to ask for your support for HB 1287, because SNAP is the best way to get people out of our lines and into the grocery store. The current limits on vehicle values prevents too many needy Texans from accessing the temporary help they need to weather a crisis like the one caused by inflation and supply chain challenges. An increase in number of our clients are making difficult choices, such as moving in with relatives when the rent has got too high, choosing between food and putting gas in their car to get a job. And the people we serve, bottom line, need reliable vehicles to get a job and to go to a job. They need reliable cars to get their kids to school. They need to be able to help the elderly get to their doctor visits. I understand, obviously, we understand why we have a test and a vehicle asset test for SNAP eligibility, but it should be based on reasonable limits. That reflect today's, it should be noted that based on reasonable limits, it reflect today's car values and be indexed for inflation.
Okay.
Chairman Frank, I'm not a policy expert, but I am someone who started out as a volunteer and now leads a food bank. I've learned a lot about immediate needs of people struggling with hunger, and I strongly believe HB 1287 is a step in the right direction to help Wichita Falls' vision of having a hunger-free community. Thank you again.
Thank you very much for your testimony. Members, any questions? Yes, Representative Ramos.
I have a question. Thank you for your testimony today and for the good work that you do. You mentioned rural communities. The bill talks about the index of the consumer price index for all urban consumers. What does that play? What part does that play in the rural? Is that just an overall? I know you said don't ask difficult questions.
I'm not an expert, but I believe it's an overall.
Okay.
Yes.
Just as
Whether
an
it's
industry
rural or
standard.
urban.
Yeah, I think I'll call the resource witness and just try to answer that question.
Thank
Any
you,
other
sir.
questions? I was going to ask you who the best coworker you've ever had was, but that's probably
It
out
would
of
be
order.
Chairman James Frank.
Thank you. Thank you very much. Thank you. Thank you very much.
Make sure that shows up in the minutes.
Long time ago. All right, thank you. Chair calls Hillary Davis with Health and Human Services. Yeah, we show you as Hillary Davis, Health and Human Services on the bill. Is that correct?
Correct,
All right. So what is the actual amount? Obviously, it's based on index, but does it start from today or does it ratchet it up from where it is? Can you go through what it is today and what it would be under the new bill as far as the limits?
Sure, yes. So right now, under the current policy, we exempt up to $15,000 of the fair market value of the vehicle for the first primary or the highest valued vehicle. Every vehicle after that is exempt for $4,650 for a second vehicle per person as well.
Okay, and so this bill would just inflation adjust that as we go?
That is our
Okay,
understanding.
okay.
It was.
I mean, that's the way I read
way
it. I
that
just
we
didn't have
were
I didn't have the starting point in the bill, so.
Yeah, so the starting point would be 15,000.
Thank you.
We did some rough math based on if we had to do this today, it would equal about 11% increase, which would increase that first vehicle value from 15,000 to $16,715, and then the second vehicle from $4,650 to $5,181.
Okay.
If we use the calculation based on how it's directed in the bill, and then that amount would be adjusted annually every October 1st. And then it would be based on inflation. Sometimes it goes down, sometimes it goes up.
And
So
this is
right
why we
now,
have
we are
resource
in a period
witnesses.
of going up.
Thank you, perfect. Representative Noble.
So I don't know if there's any way to do this, but I understand that if you, I guess I should tell you that I ran a food pantry clothes closet for 17 years, so this is my heart. Low-income Texans actually have a different pool of cars available to them than the average. Say you have a very high credit rating. Is there any adjustment made for what is available to low-income Texans? Because it really is a very different pool of availability, especially if you're having to go to a dealership that totes the note. They generally have more expensive cars, and they have to pay it weekly over such a long amount of time. And it really isn't, for those of us that have high credit ratings, it's hard for us to know what that looks like for a low-income Texan. So do y'all do any adjustments for that at all?
Sure. So federally, we are allowed to exempt vehicles. So we may look at the value of vehicles, but there's other exemptions that if the vehicle is used to transport a disabled family member or it's used for income-producing purposes, we can fully exempt that vehicle. But there's also an exemption that if the equity in the car is $15,000 or less, $1,500, excuse me, $1,500 or less, we can exempt it also. So if they owe more than that vehicle is worth, as long as it's within that $1,500 range, we can exempt that vehicle from counting towards the resource
That's good to
limit
know.
as well.
Thank you so much.
I would assume that the value is not based on what they paid for it, but based on what it is worth, because y'all, isn't that right?
That is correct. We have access to.
If somebody overpaid for a car, they wouldn't be penalized. I mean, they'd be penalized, but not secondarily penalized. Okay. Thank you. Members, any other questions? All right. Yes, Representative Manuel.
What do you all use as far as in the calculation of what the actual value, like, is it off of a Kelley Blue Book? What is that off of?
It is also off of the National Automobile Dealers Association, so NADA. So we have access to an electronic database that feeds that into our eligibility workers. So they display what the vehicles that the person owns and what that value is. They do have the ability to dispute that amount if they want to, take it to a dealer and say, yes, even though the NADA says it's worth, $20,000. I have damage. It's got high mileage. They can go ahead and give us alternative verification to say that car is not worth what the electronic database says.
Thank you.
Thank you, Representative Ramos.
Thank you. The bill specifically references the index of the Consumer Price Index for all urban consumers published by the Bureau of Labor Statistics. How does that play a part in what you just referenced? How you analyze that?
We normally, I am not as familiar with what that index is. We know where it is, how to access it, but we're not the experts. I cannot speak to how that information is calculated. We would be using that as a resource in order to do our calculations.
You would be using this as a resource, not the actual source.
We would be using the source. They publish out numbers of what those calculations is, as far as how the prices are paid, what the value is. But it's an estimated using transactions that are way above my head. So I apologize.
Understood. Thank you. Appreciate it.
Thank you, members. Any other questions? All right, thank you very much. Great job. Chair calls Jamie Olson, Self Feeding Texas, and then the only other person I show is Alex Puente. Hope I got that right. We show you as Jamie Olson testifying for Self and Feeding Texas for the bill. Is that correct?
Correct.
All right,
yeah.
thank you. Go ahead.
Yeah, good morning, Mr. Chairman and members of the committee. My name's Jamie Olson, and I'm the Director of Policy and Advocacy with Feeding Texas. I'm also here on behalf of the Texas Food Policy Roundtable, a coalition of over 60 organizations that are dedicated to ending hunger in the state. I'm testifying today in support of HB 1287 and would like to thank Chairman Guillen for filing this bill. Members, this bill is exactly the same as HB 2641 that passed this committee and passed the House last session, so thank you all for your previous support. We are also excited to have bipartisan support for this bill in both chambers, with Senators Perry, Campbell, and Sparks co-authoring SB 27 by Senator Blanco. While this bill was important last session, this bill's passage is even more critical today due to inflation. Inflation, as you know, has recently driven up the price of many household necessities, including food, utilities, and transportation. In addition, inflation has caused thousands of Texas families to lose their Supplemental Nutrition Assistance Program benefits at recertification. So what I mean by that is these families' cars, which were previously below the current vehicle asset test limit, have now risen in value so much that their food assistance has been taken away from them. No life circumstances have substantially changed for these families. They did not go out and purchase a new vehicle, and yet they are being punished for something that is completely beyond their control. The current limits, which you know are $15,000 for our first vehicle and $4,650 for any subsequent vehicles, are sorely outdated. As the chairman laid out, these limits have not been updated since 2001 and 1974, respectively. We are not, however, asking the vehicle values be updated in statute. We are simply asking that these vehicle values be indexed to inflation. This means that when inflation is high, the limits are adjusted accordingly, and when inflation goes back down, the limit will also be adjusted accordingly. I've included a graph in my written testimony that highlights the sharp increase in SNAP denials due to inflation in the used car market. In this graph, you see that SNAP denials due to the vehicle asset test stayed relatively stable for fiscal years 17, 18, and 19 at around 13,000 denials per year. In 2020, you see that these denials more than doubled to 27,000. This is due to the COVID-19 pandemic and more families applying for SNAP. However, you will see that in fiscal years 2021 and 2022, the number of vehicle asset test denials continues to skyrocket to now nearly 65,000 per year, 5 times what they were prior to the pandemic. And that is due to inflation in the used car market, not because more families are applying. We've actually seen a decrease in the total number of applications in these years. This bill is critical, and the Feeding Texas and the Texas Food Policy Roundtable support HB 1287 because no family should be denied food assistance simply due to inflation in the car market. Thank you for your time, and I welcome any questions.
Thank you. Members, any questions? All right. Thank you very much for your testimony, ma'am. Chair calls Alec Puente. I hope I got that right. I'll show you as Alec Puente with the American Heart Association and Partnership for Healthy Texas for the bill. Is that correct?
That's correct.
All right. Go ahead.
Good morning, Chair Frank and members of the committee. My name is Alec Puente. I'm the Government Relations Director for the American Heart Association, and I'm also representing the Partnership for a Healthy Texas, which is a coalition of public health focus groups focused on ending the disease of obesity in Texas. So we are in support of House Bill 1287 because inadequate nutrition can have severe long-term consequences, and we know that SNAP plays a critical role in combating food insecurity. It helps thousands of low-income Texans access nutritious foods, improving their overall health and reducing the risk of chronic conditions like heart disease, like stroke, and diabetes. We also know the majority of these benefits go to households with children, older adults, or those with disabilities, and those are all populations for whom the consequences of food insecurity can be even more severe. As you've heard today, the current asset test can lead to unfair disqualification of families who are in need of assistance, forcing them to make tough choices between retaining reliable transportation and accessing essential nutritional support. According to a recent Gallup poll, many low-income Americans are facing higher food costs, and the way they're paying the bills is in large part by delaying critical medical care. By indexing this test to inflation, HB 1287 will ensure that more eligible families can benefit from SNAP without sacrificing their ability to work, to attend medical appointments, or to take care of their family's needs. We know that research has shown that SNAP not only alleviates hunger, but can improve diet quality and health outcomes. When families can afford nutritious foods, they're more likely to have a balanced diet that supports overall health and reduces their risk of chronic disease. And they're more able to build healthy habits that they can sustain within their budgets in the long term. Updating this test will enable more families to access these health benefits without compromising their mobility and economic opportunities. Thank you for your time and your consideration of this important bill.
All right, thank you, members. Any other questions? Now, I appreciate you focusing on the nutritional aspect of it. So the SNAP benefits, and I apologize, I maybe should ask the resource witness, but I think you may know, are loaded onto a card?
I believe that's the typical way they're used, yeah.
And then they're spent where?
They're spent, I think typically at grocery stores where the rest of us would shop.
Okay.
And there are other measures and bills we're working on that can help encourage people to make healthier choices there as well, in addition to getting better access to the program.
Okay, thank you very much. Members, any other questions? All right, thank you very much. At this time, there are no other witnesses signed up to testify. Is there anyone else wishing to testify on, for, or against House Bill 1287? Seeing none, public testimony is closed, and the chair recognizes Representative Guillen to close on House Bill 1287.
Thank you, Mr. Chairman. If there's no further questions, we'll be working on that committee sub with stakeholders and get it right back to you as soon as possible.
Okay, awesome. And you close?
Yes, I close.
All right, thank you. If there's if there's no objection, House Bill 1287 will be left pending. Is there objection? Chair hears none, and House Bill 1287 is left pending without objection. We're going to do one more bill, and then we will take a recess for the floor and then come back, and that will be, Chair lays out House Bill 1141 and recognizes Representative Cortez to explain his bill.
Good morning, Chairman, members of the committee. Such a handsome committee that we have here. Impressive. Most impressive.
Most impressive.
Attractive.
Careful now. All right, move on.
Thank you for the opportunity to lay out House Bill 1141 for the committee. In 2017, the Health and Human Services Commission abruptly eliminated the grievance procedure for nearly 40,000 of its employees. This change, implemented without legislative approval, reversed the due process protections that had long safeguarded state employees, whistleblowers, ensured supervisors and administrators were following labor laws, and reduced the state's legal liability for decades. State employee whistleblowers call attention to potential abuses of power or actions that undermine state services and cost taxpayers millions of dollars. House Bill 1141 directs the Executive Commissioner of the Health and Human Services Commission and Department of Family and Protective Services to establish an employee grievance procedure to allow employees to appeal an employment action taken by the Commission or Department. This will allow employees to appeal disputes regarding disciplinary actions, reprimands, demotions, suspension, reductions in compensation, and termination for cause. We look forward to working with the committee members, and I thank you, Mr. Chairman, for the opportunity to lay out House Bill 1141, and I reserve the right to close.
All right, and you certainly will have that. Just from a background standpoint, what brought this to your attention?
We had
because I would have thought this is already in place, but apparently it's not.
It was in place up until 2017, and it was removed.
Okay, and do you know what caused it to be removed? Was that legislation or?
No, sir. It was done purely within the bureaucratic.
Okay,
rules.
and I apologize if that was part of your layout. I was doing multiple.
I did mention that, but that's fine.
Yeah. Okay. Very good. Members, any other questions? All right. Thank you very much. Chair calls Christy Carrington, Self and Texas State Employees Union for the bill. And I show one other person, Tyler Shelton, is on deck. And I am going to call the resource witness in this. What's that? Karen Ray. So we show you as Christine Carrington testifying for Self and for the Texas State Employees Union for the bill. Is that correct?
Yes, sir.
Okay, thank you.
Thank you. So we're asking that a grievance procedure for DFPS and HHSC staff be restored. While it is a given that many disciplinary actions are warranted, all are not. Without an appropriate and fair grievance process, many staff have been victims of disciplinary actions that are retaliatory, excessive, and clearly an abuse of power by their management. Both DFPS and HHSC face real challenges that require difficult and candid conversations in order to make important and necessary changes. So staff need to be able to speak freely without fear of retaliation and intimidation. I would also say that having a fair grievance process helps establish a more dedicated and committed workforce. Without it, employees lean more towards appeasing their supervisors rather than focusing on policy and the needs of the populations they serve. So, for example, there have been staff that have said that they've had fear of insubordination because they didn't participate in the party. I've had staff tell me that, they've been asked to violate policy to circumvent getting some things done. So, basically, the job itself is hard enough. So, to worry about your livelihood should be part of that process, and just a fair grievance process.
Okay. And do you know I'm sorry, you done? There.
Yes, sir.
Okay.
Yes, sir.
Do you know what the grievance process is now? Because there is some grievance process now, I assume. It's not an at-will, and I can ask
With DFPS, I know that there's an informal process, so that if you get some type of disciplinary action, you can write your your next direct report of that. So if it's a supervisor, you can speak with the program director. If it's the program director, the regional director. So that's a letter or email that you can send to that individual, but there's no process like a committee, and you air out the grievance and things like that. So there is somewhat of some type of redress, but not a grievance process per se.
Okay. Thank you. Members, any other questions? Okay. Thank you.
Thank you.
Thank you. Tell you what, I'm going to ask the resource witness, Karen Ray. There we go. And we show you as Karen Ray with Health and Human Services on the bill. Is that correct?
That's correct.
All right.
Good morning.
All right. Good morning. Could you briefly show what or say what the current grievance process is, and then what this bill would contemplate adding to that grievance process? Because unless there's not one now.
There is one now.
Okay.
I want to clarify first, I am Karen Ray. I'm Chief Counsel for the Health and Human Services Commission, which is one of the agencies addressed here. I can't really speak to the processes at the Department of Family.
Thank you very much for the clarification.
Okay, currently.
And by the way, members, we do have one for DFPS if you want it, so go ahead.
Okay, I'll take the current grievance process first.
Yes, thank you.
And it's helpful to think, our HR policy divides our employee population into 3 groups for this purpose. The first is a group that includes the employees of our state-operated facilities. So those are the state-supported living centers and the state hospitals. That group has the right to notice and an opportunity to respond. So they get notice of a proposed disciplinary action.
Would you mind can you stand
sorry.
up? Just there you go.
I was trying not to lean.
Yeah. Lean away. I think it's easy.
Okay.
There's just some background noise.
Okay. So those employees get notice and an opportunity to be heard on any disciplinary action. If the disciplinary action is completed, they have the opportunity to grieve that decision. So that means an administrative hearing in front of our in-house ALJs. So, second group is the group of employees who are classified up to salary group B26. For reference, the midpoint for that salary group is around $93,000 a year. That group, for any disciplinary action, and I keep emphasizing that because that's a difference we'll talk about in a second, that group has, again, notice and an opportunity to be heard on a disciplinary action, but they do not have the opportunity to go on to that grievance appeal, the administrative hearing. The third group is the group of employees who are salaried at B26 and above. That group is at will, as are most employees.
Okay, so the higher up is actually at will, and then the lower.
Correct.
Higher in salary. I don't mean.
Correct.
Yeah.
That's correct.
Okay.
So the bill would make a couple of important changes. First, those three distinctions would no longer exist because all of HHSC's approximately 38,000 positions would have the opportunity to go through the whole process. So up through that grievance and the administrative hearing. In addition, the bill would contemplate making that administrative hearing, which at this point is kind of informal, into a contested case under the APA, which would then entitle someone who's not satisfied with the result of the hearing to judicial review.
Okay.
So the length and the complexity of the process, maybe the formality of the process is a change. Additionally, the bill very much expands the number of things that an employee could grieve. Right now, those are limited to suspension without pay for disciplinary reasons, involuntary demotion for disciplinary reasons, dismissal, and written reprimands, but only for confirmed cases of abuse, neglect, or exploitation. So the bill adds to that a number of things, most notably any kind of oral and written reprimand, or complaints about working conditions and hours. So the number of grievances that we see now would only represent a fraction of the number covered by the bill. And in addition, it would cover more of our employees.
Okay. Thank you very much.
That helpful?
Yeah, actually very helpful. Thank you. Members.
I'm so sorry.
No, go ahead.
May I? Just with reference to the change, when in the law today, there are two provisions that provide additional due process for HHSC employees.
In the law today.
In the law today. Those are our state-operated facilities, the state hospitals and the state-supported living centers.
Okay, thank you very much. Honestly, I was surprised, and I appreciate you, Representative, bringing the bill. But my knowledge on this was like 8 years old, but I had a long conversation with one of the commissioners, and I was like, okay, if somebody steals, how long does it take to remove that person? And the answer was about 4 or 5 months. And I'm like, and so I'm asking, if an employee is caught stealing, how long does it take to remove them under current rule?
He could be removed immediately, but the process will go on, and there could be a chance at the end of that process that termination could be undone.
Yeah.
Right.
Okay. Because I just didn't, but that was also honestly before whatever change was made in 2017. Was there a major change made in 2017 or the?
So many years ago, when the Health and Human Services system combined, we became one very large employee population. And at the time, as now, only the employees of those state-operated facilities had this additional due process provided to them. So there were policy changes at the agency because we provide HR support and legal support and other kinds of support across that whole population to treat the entire employee population similarly. And probably around the time you were having those conversations, there was a look at how long some of these processes were taking. What is the agency required under law to provide? And we made adjustments to our policy at that point.
You don't want, you got a question?
I was-
Chair Rose.
Thank you, Mrs. Chairman. I was just trying to get a little clarification as to why was the process removed? The grievance process in 2017.
It wasn't removed, it was tailored to what is required under the law. The employees of the state-operated facilities who, under two provisions of the Health and Safety Code and an Attorney General opinion, are entitled to that additional process, still have the notice and opportunity to be heard, and in addition, the grievance and the grievance appeal.
I'm guessing did it also have something to do with the fact that those agencies were being collapsed? My guess is when you put those agencies together, you're also looking at all the HR policies.
That's correct.
So that was happening about that time, so I assume that was part of the process.
Okay, well, let me ask it this way. So what's the difference between the process now and the process that Representative Cortez is trying to implement?
The difference between the process we have now and the process outlined in the bill, it would more than double the number of employees who go through that whole process. So notice and opportunity to be heard, grievance, administrative appeal. It would change the character of the process because the administrative appeal, which is at present fairly informal, would become a contested case under the APA, involving most notably then the right to a judicial review. So it would lengthen the process. And it would also increase the number of actions that would be subject to the process.
Okay, thank you.
All right, thank you very much. Members, any other questions? I think, yes, Representative Ramos.
So essentially, there's a laundry list, and after 2017, the laundry list was significantly reduced in terms of what employees could file grievances or.
Sort of.
Okay.
Sorry, I should have let you finish. What happened in 2017, and I'm saying that date, I can confirm the policy, the dates of the policy change. What happened when we changed the policy was not all of the commission's employees had access to that administrative appeal. So I believe, but I can confirm, that it was the same list of actions that an employee could challenge. It was just fewer of those challenges went all the way to the administrative appeal.
Okay. The fiscal report, it says the analysis with regarding to HHSC assumes that 25% employees would file a formal complaint. That's alarming. Why? That's a quarter. What that statement to me screams there's so many violations that of course all of these people are going to file a complaint because they haven't been given that avenue to do so. Could you explain that a little or talk a little bit about that statement?
Sure. I think that is an attempt to estimate the impact of the additional actions that an employee could grieve. So something like an oral or written reprimand, where we can understand what a formal reprimand, usually a written reprimand is what an oral reprimand might be, or what someone might perceive to be an oral reprimand, and then want to take through the grievance process is a little bit of a question mark. Likewise, with the complaints about working conditions or working hours, as you all know, we have a number of facilities and other programs where people are working long hours and under challenging conditions. But if each one of those employees were to grieve that would dramatically increase the impact of this process. So the 25% is
Did you just say if each employee was to grieve the fact that they were given this extensive responsibilities and it sounded to me like you said in violation of like work hours and
No,
excessiveness that's being required of them, that they would then be allowed to grieve that.
No, my apologies. And I do want to be clear on that. My flawed example was there are a lot of new grounds, potential grounds, that are outlined in the bill. And not all of those are, at this point, well understood or well defined. So I think that 25% was an estimate based on the number of grievances that we see today for a limited number of grounds, and then with the unknown number of new additions.
Thank
All
you.
right, members, any other questions? I think we're going to have to recess, and then we'll, if there's no objection, the chair moves to leave HB 1141 pending. Is there objection? The chair hears none. HB 1141 is left pending. The chair moves that the committee stand in recess until final adjournment or recess of the House, or during bill referrals if permission is granted. Is there objection? Hearing none, the motion prevails. The committee stands in recess.